To that end, the Good Legal Stories series spotlights landmark environmental cases from around the globe through the voices of those who worked on and decided those cases. Today, we're really excited to hear a good story from Montana in the United States through the experience of Kim Wilson, who was one of the lead counsel in the case of MEIC versus DEQ, the landmark case enforcing Montana's constitutional right to a clean and healthful environment. Jimmy, will you introduce us to Kim?
Yes, absolutely. Yes, as Erin mentioned, we're just so delighted to have Kim Wilson with us, the lawyer who worked on one of the first and foremost cases involving a right to a healthy environment, as Erin mentioned. Let me tell you a little bit about him. Kim has been with the law firm in Montana, Morrison, Sherwood, Wilson, and Deola, representing Montana citizens concerned about protecting Montana's environment and landscapes and other public interest matters. He has an active litigation practice and has settled or tried hundreds of cases. And he was one of the lead lawyers in the MEIC case versus the Montana Department of Environmental Quality, in which the Montana Supreme Court first enforced Montana's constitutional right to a clean and healthful environment. That's expressly in the Montana Constitution. He's a graduate of Montana School of Law and has previously been the editor of the Public Land Law Review. Kim, welcome, and tell us about the case.
Thanks. So just to give you some kind of broader background and context, this case was about a mine that was proposed on the banks of the Blackfoot River in western Montana. The Blackfoot River flows downstream into the Clark Fork, which then flows into the Columbia. And the mine itself, the proposed mine, was fairly close to the headwaters, probably 20 to 30 miles outside a town called Lincoln. And this area, this valley, had been kind of a corridor for Native Americans for millennia, long before whites came along, as a passageway to get from the west side of the divide to the east side to hunt bison and other animals. And so it was kind of a well-known travel corridor. And actually Lewis of Lewis and Clark went over what's now called Lewis and Clark Pass, about 20 miles upstream from the proposed mine site, on his way back to St. Louis, I guess. And ironically, he had the pass named after the two of them, even though it was only one of them that went over the pass, and they spent only one day doing that. Whereas, of course, the natives have been using it for thousands of years. But in any event, if you fast forward to present times in the late 1900s, in, I think, mid-1970s, Norman Maclean wrote a book called A River Runs Through It. And that became kind of a classic of Western literature, and was then made into a movie in 1992, and was about this family and largely about fishing on the Blackfoot River. And as a result of both the book and the movie, but even more so the movie, the Blackfoot kind of became this iconic Montana river. And it's a beautiful river. Its headwaters are in the Scapegoat Wilderness on Scapegoat Plateau. It's got several branches that flow out of the wilderness that all meet right near where this proposed mine was going to be. And in the mid-1990s, a mining company proposed a massive open pit mine at this site, which was where the Landers Fork of the Blackfoot joined the main Blackfoot. And as part of their exploration permit or work, they had to drill a bunch of test wells. And in doing so, they then had to discharge water from these test wells. And because of the nature of the geology, the discharges were going to be laden with arsenic above naturally occurring levels in the receiving waters in the Blackfoot River. And so, and despite that, DEQ, relying on a statute that the legislature had passed, created an exemption, or that had created an exemption for these kinds of test wells. So a blanket exemption. And yet in this case, my clients discovered that, even once you got to the end of the mixing zones in the receiving water, there would still be arsenic above levels and at levels that would potentially harm human health. And so we filed the lawsuit in the late 90s and challenged the constitutionality of that particular statute in an as-applied challenge. And the organizations who were part of it, and it's been long enough, I may not remember all of them, but it was Montana Environmental Information Center, Women's Voices for the Earth, the Clark Fork Coalition, and there may have been another one in there as well. So 3 or 4 organizations, but MEIC was the lead. And it went ultimately to the Montana Supreme Court, where the court issued the decision that you were talking about. And in a very detailed decision, the court kind of shone a spotlight on this unique right to a clean and healthful environment. The court talked about the high level of scrutiny that any environmental regulation in Montana would have to pass in order to kind of pass constitutional muster. In one memorable line, the court said the Constitution doesn't require that dead fish float on our rivers before the protective provisions of the Constitution will kick in. And so the court ultimately found that the statute was unconstitutional. And as you discussed, it was the very first time that the court had kind of significantly interpreted that provision of the Constitution. And as I think I said, more recently, there's a newer decision, finally, 20 years later, that kind of adds even some more flesh to the bone there. But it was a major victory and a major decision. What the mine at that point was stalled, if you will. And this mine would have been maybe not as big as the Berkeley pit, which is the really massive open pit copper mine in the middle of Butte, Montana, but was going to be real close to that size. So it would change the whole landscape of the Upper Blackfoot. Soon after this decision, and kind of in tandem with the same groups and in tandem with the litigation, there was an effort to put on the Montana ballot an initiative that would outlaw, a constitutional initiative that would outlaw the use of cyanide heap leach technology in mining. And what that basically would do, or does, is prevents going forward any large scale open pits from being economically viable. And that initiative, and I don't remember what year it passed, but soon after this decision, that passed, and that effectively put to rest this mine. There was a follow-up appeal by the mining company alleging a taking as a consequence of the initiative, and the Montana Supreme Court ruled against them. And so that mine, I drive by it frequently on my way to hiking or backpack trips, and it's just a pristine hillside like it was, before this mine was proposed. The one thing I would add with that initiative on the cyanide heap leach is that, the history of mining in Montana is lots of failed promises and lots of unreclaimed open pits, and lots of water quality associated with that mining activity. And at the same time that this litigation was going on, there was a similar lawsuit challenging the mining by a mining company called Pegasus Gold on the Zortman at Zortman Landusky on the Fort Belknap Indian Reservation, where a huge open pit had been approved and permitted, and it resulted in severe water pollution for the towns downstream. And then Pegasus, not surprisingly, filed for bankruptcy. And now, so over the last 20, 25 years, the public, with what was left of their bonding, has had to deal with trying to clean up the mess left by this bankrupt company. And it has particularly taken its toll on the native communities immediately downstream of it. So anyway, the banning of cyanide, basically the forbidding that kind of open pit gold mine that came out after my MEIC decision, really had some broad, hopefully good impacts in the future, and that we'll be able to avoid some of these things in the future. But notably, the pollution is forever from a lot of these mine sites. And just as an aside, I remember deposing a DEQ staff person, geologist, I guess, on one of my mining cases where the reclamation plan included the need to treat the pollution in perpetuity. And I said, well, so what does in perpetuity mean to the state? And he kind of shrugged his shoulders. He goes, I don't know, till the next best thing comes along. And so, in perpetuity means this is going to happen forever. We're not going to be able to treat it forever because, who knows whether the technology will still exist or whether the money's going to be there. So the history of mining in Montana is lots of failed promises like that. And I think this MEIC decision kind of created a great kind of foundation of constitutional principles that the right to a clean and healthful environment means something. But honestly, I've been litigating the 22 years since then, and it's still always an uphill battle, battling the forces that are trying to develop the natural resources.
What a great overview of this story, and sort of highlighting the long-term impacts that are both good and not so good of this kind of work. I'm wondering if you can take us back to sort of the heady days at the beginning of the litigation, when you first were thinking about using the Montana Environmental Rights Amendment to base the case on, or to base your claim on. And it had been in the Constitution for more than 25 years at that point. And I'm just wondering what your thinking was about using that. And also if you could just describe sort of any particular challenges you had in making that constitutional environmental claim. I know that's what to ask in just a few minutes, but just if you
right,
could.
and it's been a while, so the details of the discussions in the room I don't necessarily remember. So I was lead counsel or co-lead counsel with Tom France from the National Wildlife Federation's northern, I guess it's called Northern Region or Northwest Region office in Missoula. And I do remember spending a significant amount of time in utilizing Tom's interns, researching that very issue and trying to figure out, okay, is there an angle to do this here? And but we put the case together kind of aspirationally. I mean, because we were trying something new. We had the good fortune of being able to have as our expert, and in the case, a gentleman who had worked for DEQ till like 2 years before that as the head of the water quality division. So he certainly knew on the ground what this stuff meant, and essentially turned on his former employees or employer. But yeah, we knew we were doing something new and different. And a couple of, notable things stand out for me. One was after losing at the district court, we had a powwow with other attorneys and other activists about whether we wanted to appeal this to the Supreme Court. And lots of people were urging us not to. And so at least one of the groups, I believe, withdrew and didn't participate in the appeal. But once we got it up there and the briefing, I think we did a good job of briefing it. I do remember the hearing at the Montana Supreme Court, which I didn't do the argument, Tom France did. It was just a stirring moment because the court really understood the importance of what was going on. The industry attorneys and DEQ attorneys were relatively inept at kind of handling the broader policy issues that were before them. And at the end of the day, it was a very strongly worded decision by, at that time, one of the more progressive justices on the Supreme Court.
The case is a great example, a great exemplar of the utility of patience, isn't it? The provision was adopted in the early 1970s, and then this case is more than a quarter of a century later, as Aaron mentioned, in the late 1990s.
Right.
And when it was decided, unless I'm mistaken, it was one of the first times any court anywhere on the planet had engaged a constitutional right to a healthy environment. So it takes time.
And then, as I said, we've been waiting patiently, and 20 years later, last December, finally got a follow-on decision that was really strong, despite numerous efforts in the interceding years where we would try to use that right to a clean and healthful environment to buttress a case, one sort or other, whether it was water quality or mining or MEPA, to no avail. And so it is a long, it's a long fight. I mean, I've been doing this for 35 years, and it sometimes feels like you're on a treadmill.
Yeah, and as we celebrate the 50th year of this important constitutional right, it was just great to have you as part of this program. So let me thank you again, Kim, and on behalf of the Normandy Chair for Peace, thank all of you who have watched. We'll see you next time. Take care.